Supreme Court placing new limits on how police can test suspected drunk drivers.
And the ruling means police must get a search warrant to take blood tests, but they don't need one for breath tests. Fox 9's Ted Haller joining us with more on this. Ted?
That's right, Jeff. This concerns the Minnesota law that makes it a crime to refuse a blood, a breath, or a urine test even when police have no warrant. Well, today the Supreme Court said even when there is no warrant, you still have to do a breath test. But you don't have to do a blood test. Now, as for the urine test, that's where it's a little bit more gray.
So this is the actual machine.
Attorney Jeff Sheridan keeps a breathalyzer in his office. It's his case concerning a Minnesota man who refused a breath test, all the way from this South St. Paul boat ramp to the U.S. Supreme Court. The court deciding his client could not refuse that breath test, even though police had no warrant. But a blood test, the justices said he could have refused.
Everybody wanted a nice, clear decision, and today we took muddy water and we threw more dirt into it. This is the decision nobody wanted.
Normally, police need a warrant to search, but there are exceptions, like when police arrest someone and search for weapons or drugs. The majority's logic is that a breath test is similar to an arrest search, but that a skin-prickling blood test is much more invasive.
The government always wants evidence. The question is, are they willing to put in the effort to collect it in a constitutional fashion?
Ironically, this holding provides greater protection under the Fourth Amendment for drug users and potheads than it does for social drinkers.
DWI attorney Chuck Ramsay said courts will now deal with a logjam of cases that were waiting for this decision.
Thousands.
Really?
Literally thousands.
Then there's the question of urine tests, not addressed by the U.S. Supreme Court. The Minnesota Supreme Court is now deciding. Ramsay's firm handled that case.
The privacy interests in urine testing are actually greater than in blood testing.
Dakota County Attorney Jim Backstrom praised the decision. It's his office that prosecuted the original case that's been on hold now for a long time as it made its way up to the U.S. Supreme Court. So his office will now resume prosecuting that defendant, William Bernard. Kelsey and Jeff.
All right.